Sometimes, no matter how much coaching we've done, we will find that some associates will need corrective counseling. So it's important to prepare adequately before taking that step. Before you begin counseling, it's important to do your research. Review the employee's record. Consider facts only, not opinions, and read through their past performance reviews. Two of the main keys to successful corrective counseling are documentation and consistency. Do an investigation into the facts and circumstances that you're counseling the associate about and take very good notes. Get witness statements if that's relevant. Be consistent. Again, make sure you're handling similar issues the same and be mindful of perceptions from protected classes. Let's take a closer look at what we mean by the term protected classes. When delivering corrective counseling, we don't want the associate being counseled to feel that the facts we are addressing have anything to do with anything that would be inappropriate. A list of protected classes, areas of the law that would be inappropriate to consider in any kind of termination or corrective counseling situation would be the associate's age, their gender, their race or ethnicity, their religion, disability, veteran status, or that the action is some sort of retaliation for them filing a workers' comp claim, a Family Medical Leave Act claim, an Americans with Disabilities claim, harassment, safety violation, or any of the legal areas where retaliation is a concern. The counseling process is designed to be progressive. Remember, the goal is to provide associates with feedback and notice of their development needs so they have an opportunity to improve their performance and be successful. So the timing is essential. You want to be fair. An associate who isn't aware of what they're doing wrong has no opportunity to do better. Now, depending on the severity of the situation, sometimes steps of progressive discipline can be skipped, and we'll talk about that a little bit more in a moment. So when should counseling start? Don't procrastinate. Start counseling sooner rather than later. Remember, your associates can only benefit from this constructive feedback. Now, it's typically a best practice to go in progression. So starting with a verbal warning at the first sign of poor performance that your coaching didn't resolve. Now, counseling for a policy violation should happen immediately following the events that are relevant. If too much of a time gap exists between the events and the counseling, it casts a shadow over your true motivation. Next, let's review all the steps in the counseling process. But first, be sure you're consulting with human resources if that's relevant in your organization, or legal counsel when appropriate, especially before delivering a termination notice. The typical progressive steps in corrective counseling start with the verbal warning, which represents the initial documentation to try to improve an issue that proactive coaching wasn't able to resolve. The next step would be a written warning, which is the follow-up to the verbal if the behavior continues or the performance issue continues. Then you may go to a final written to make sure the associate knows that if their performance or the behavior does not improve, termination will result. And then finally, a termination notice. This documentation is very important. Be sure that the final circumstances are articulated well. Another best practice to help accomplish the documentation, which is critical in the corrective counseling process, is to have a disciplinary notice form. I've included a sample here. As you can see at the top, it just has the critical information, the employee's name and their job title, and then a place to indicate what kind of disciplinary notice we are delivering. You may also want to include details of the violation. What kind of issue is it? Is it a policy issue, an attendance issue, and so on. Two other critical pieces is to make sure you explain the events that led to the corrective counseling issue. And then also list any prior warnings or disciplinary action that is related to this issue. So especially if it's a written warning or a final written warning, you want to make sure that you show that you went through progression. It's also sometimes helpful to have a summary of the corrective action being taken and any consequences of failure to improve. So will there be a follow-up performance discussion? And if there's no improvement, will the next step of discipline result, or will termination be the next step? Then it's very important. The most important part of the form is the signature and the date at the bottom. Oftentimes, employees will refuse to sign a disciplinary notice, which is why I always recommend having a witness in the meeting with the manager to sign that this document was presented to this associate in my presence. You may consider, though, including an employee statement and acknowledgement in there where they can sign off saying, yes, this was delivered to me, but I don't agree with it, and there's an opportunity for them to provide comments. Sometimes that'll get you over the hurdle of, I don't want to sign this form. But if you have a witness sign that it was presented to them, that really is sufficient. Another tool in the counseling process, which can sometimes be helpful, is a performance improvement plan. You would use this type of a document when you need to identify specific issues that an associate needs to improve their performance. It serves as almost a roadmap of the things they need to do to be successful. This type of plan may exist with or without corrective counseling. It can actually serve as a verbal warning if no other foundation for corrective counseling has been created. It's not for every issue, though. Really, just performance issues, maybe attitude, are appropriate for a performance improvement plan. But it wouldn't be appropriate for something like tardiness, because really they just need to not be tardy. There's not much else to say. I mentioned earlier that sometimes you may not want to be progressive with your discipline. So when is it appropriate to skip steps in the counseling process? First, it's important to understand your policy. Do you have an employee handbook? Is there a policy where the company reserves the right to bypass steps in the progressive discipline process? That is, of course, recommended. Examples of serious issues that you might include in such a policy that warrant skipping steps are things like overt sexual harassment, stealing, falsifying your time card, threats of violence, insubordination, or walking off the job, to name a few. I always like to include in my policies a footnote at the bottom that says this list is not exhaustive, so you don't remove any flexibility you might want for an issue of first impression.